Hello everyone, I am Sergio Maldonado and this is Masters of Privacy, a set of interviews covering the intersection of marketing, data, privacy and technology with a clear goal in mind, which is redefining the relationship between people, brands and media around transparency and control. Which is to say, we're aiming for real customer centricity, or if you will, human centricity. We regularly talk to DPOs, CMOs, CDOs, and whoever else we find interesting and able to share valuable insights. So we hope you like it. Please do reach out if you have any ideas on future topics or speakers. Okay, we've got Simon Hania. He is the Global Data Protection Officer at Uber. Before that, he was VP of Privacy and Security at TomTom, having held various roles in IT service management in the past. Simon is a trained engineer who has learned to love the law, in his words. This is a wide-ranging conversation. We start with the role of a DPO and then go into vendor audits, Uber ads, location data, and AI governance. Some of you will wonder why we have not gone deeper on the topic of data transfers and the Uber fine, but the fact is that the issue is still very much alive and open, so we will have to wait for further analysis. Plus, I had already covered what we already know in our last newsroom. I will refer you to that if you're curious. For now, we've got enough on our plate. Let's go for it. Simon, thank you for joining me.
Thank you, and pleasure to be here.
So, Uber received a 290 million euro fine in the Netherlands. And to get started, what has your role as a DPO been in that process?
Well, normally as a data protection officer, of course, you're a guide, a watchdog, and an ambassador in a way. That's essentially what GDPR requires you to do. But in case of such an investigation, the role shifts a bit. It shifts because the Dutch Data Protection Authority really wants to deal with the data controller at that point in time. And essentially, as a DPO, you then start to take a backseat role, which still means you're guiding, helping. You also are a bit of a watchdog, also to make sure that the data subjects are well served by potential conclusions or even sanctions the data protection authorities may impose. But the role of ambassador shifts to the role of observer. So I've been largely observing this and not meddling with it too much.
Okay, so moving on to something I wanted to ask you, which is auditing vendors. I'm quite immersed into that dilemma. So, do you apply any best practices? I know you're very busy. You've got plenty of marketing technology vendors in your stack, and there'll be people in procurement, and there'll be people in info security dealing with the audits. But is there something that you apply, and how far ahead do you intervene whenever a new piece of marketing technology is being onboarded?
So for me, it starts again with the risk-based approach enshrined in GDPR and the role of the DPO, guide, monitor, and be the ambassador, which means that if it's about auditing third parties, the monitoring role is an important one. You need to be able to scale it. So very important to look at the risks, but also do not consider, I would say, the DPO as the person or organization that has to do the third-party monitoring. I still think that's an obligation of the data controller, whom you advise and guide. It's the data controller to set up some sort of an approach to do this, do that as a one-off before onboarding, do it based on risk classification related to number of data subjects, volume of data, nature of the data, everything GDPR essentially puts you to do. Build a structure around that and repeat it. And if as a DPO, you can monitor that structure, those processes, then I think you can achieve what needs to be done. There's a first line of defense, so to speak, of actually looking at this, not only in terms of data protection, but also in other areas, intellectual property protection and so on. So piggyback on that. And then the data protection officer will help to ensure the process is run well, is risk-based, touches the GDPR elements. And that's, I think, the best way to do
Good.
it.
Well, thank you. Do you think it could get to the point where it permeates through other teams, like even marketing? Because marketing or CMOs often are buying pieces of technology. They end up dropping all these pixels on your websites, on SDKs, and your mobile apps that are now being subject to even lawsuits in the U.S. So can it get to that point where you lay out the grounds for them to understand what's acceptable?
So over the past year, also before joining Uber, what I found is that actually marketeers want to achieve their objectives and are really not interested in uh, violating the law on purpose. So what you need to do is explain to them what the rules of the road are. They may not like them, but you can also point them at the consequences, because in the end, if you really do it wrong, you may incur a ban on processing, and then your performance marketing will heavily not perform. So, that's the ultimate one. So what I also see is that a lot of the technology vendors are also coming out with better approaches, and the fact that some coalescence in this market is happening could help as well. One other thing as a DPO, which you can also do, is have a conversation with your peer DPOs in this respect. You speak the same language, should have the same goals, and then you can get where you are.
Very good. Thank you. Yes, when there is a DPO, I think, yeah, you're right. That makes it easier. Okay, so I need to ask you about Uber Ads. If you can tell me anything about that. I know it's developing farther and faster in the US, but there's two plays in the Uber Ads world. There's the data play, where you're sitting on top of all of these, what we call first party data. There's a lot of it, which Uber controls. And so there's plenty of agreements in, for example, the context of data clean rooms, so that you can work together with publishers or other commerce media or advertisers so that they can better understand their audiences. And then there's an inventory play where people are seeing ads, like video ads, on the Uber Eats app in France, for example, or in the Netherlands. So both are working. Have you had to advise that new initiative in any manner, or do you see anything coming our way when it comes to that commerce media, which is growing quite a lot?
Well, yes, of course, I've been involved in advising on that because it's just the regular guide part of the DPO. And I think it's also important to point out that these ads or sponsored listings, as we call them, are an important tool for restaurants to generate traffic to their restaurant, literally the traffic from the couriers. So it's really on the app itself. It also relates to people's preferences and what they can see. So it's quite a business in its own right, but it's also very supportive of the various merchants on the platform. So it's really multi-sided, multi-stakeholder interest, which makes it really interesting for a DPO to advise on, because the first thing as a DPO, in my view, you need to do is follow the data. What's actually happening? How is this being done? What are the data flows? Who's involved in order to make that assessment? And as I already told you, I have an engineering background. Folks in my team also have an engineering and risk management background. Not many lawyers around. We have enough lawyers, but not in my team. And that is a great boon to be able to understand it and to actually also have a conversation with the engineers who built it in what the right way to build it is. So a lot of the technology we build is developed in-house, and that for us has a great advantage because we can help shape it. So yeah. Heavy involvement.
That's so good. That sounds very interesting. And the fact that it really is a new frontier in terms of targeted advertising, where you have your audience, they could define their preferences. You're not sharing data when it comes to your inventory, that I understand, with others, and then there's all sorts of advertising happening. So you're talking about restaurants getting traffic, and there's also top of funnel like Canal Plus. I understand they did a campaign in France. So I can see that evolving quite a lot. It's all the rage these days with everyone I speak to in Martech or AdTech, the whole idea of commerce media. So I think that we'll hear a lot about that. And there's so much, again, as well about the DSA and whatnot. I'm going to change tack entirely into location data. There was a fine in Spain early this year issued to Glovo, the food delivery company, which competes with Uber Eats. And they were sending, it started in Italy, but because of the one stop shop, it was issued by the AEPD. And it was about sending location data about they call it the Glovers or something, the delivery people. It was being shared across countries, and so it was done under Article 25, so privacy by design and default principle. So Article 5 as well, data minimization, and there was also a mention of Article 32, so not enough security measures. So that's the context I've got. It's very recent. It is from February this year, and it's about an app that is very similar to Uber Eats. How do you see location data? How do you deal with it? What's your perspective?
Well, location data, of course, is very foundational in the delivery and transportation business because it is the way in which you get from A to B as an individual. The navigation requires location, so that's what it starts with. And then the app, also the Uber app, collects the location data from your phone, and on the device itself, it uses that data to put stuff on a map and so on. It also sends it back because as a company, we need to know where the courier is in order to match the courier with the restaurant and the person having ordered. So that's why location data is so fundamental.
Very good. So going back, there's two worlds to. So the way I see location data, and you correct me because you're going through this every day. There's location data as it affects the carriers. So if you remember in the EU, in the e-privacy directive, we had a distinction being made as to whether you were an e-communic or a communication service provider or something like that. So an ISP, where there's some conditions imposed on them, and that doesn't affect us here. And then how it affects the apps, mobile apps, and any other player. In the US, to give additional context, there's the FCC that has been issuing big fines this year, so that's very recent, to all the big telcos. So it's up to $200 million or something. So T-Mobile, 80 million, big fines because they were selling location data. And the FTC also wanted to put an end to data brokerage in location data marketplaces. So they also stopped two other companies. There were two big cases. One is called OutLogic, Xmode at OutLogic, and another one I can't remember now. But so the FTC going after most players, especially if it's sensitive data, location data, for example, about hospitals in a sensitive year after Roe v. Wade in the US. And then there's location data from the FCC point of view. In the EU, we have the e-privacy directive, we have it, and then we have the GDPR. How do you see location data pre-GDPR and after the GDPR, and when does it constitute personal data? And I'm sorry about the long question.
Yeah, it's good you refer to the telecommunications service providers because inherently already for decades, as part of their networks, they keep track of where the phones are. They have to because otherwise they can't deliver the call to you that's inherent to mobile networks. And that's why in Europe, with the advent of GSM, the standard, lawmaking caught up quite immediately and imposed very specific rules on telecommunications carriers with respect to the location data. And it boils down to the fact that they are only allowed to use it strictly for the provision of the service or to create the invoice. It's called the metadata or the traffic data, as the law calls it, or they need to have permission from the user to use the location data. And this is where telecommunications providers are under strict scrutiny, not by the data protection authorities, but by the telecommunication authorities. And actually, I just read in the Netherlands, for instance, a case in which the three networks here, two of them were fined by the authority overseeing this for having shared location data with private bodies that aim to create heat maps of traffic densities across the country. And that was seen as not lawful because it is not strictly necessary for the telecommunication service, it is for other services. And there was one communication provider who actually refused to cooperate with that company and said, we can't do that as a result of law. So you could also argue that in a way the telecommunications providers are a bit disadvantaged compared to those who, with the advent of GPS, have been using collecting the data themselves using the GPS and Wi-Fi signals, so not the telecommunications signal. And that's where GDPR also or previous data protection legislation kicks in, the use of the GPS positions. And then there is no strict prohibition, but you need to have a legal basis, which could be consent, of course, but it could also very well be having a contract for a service which requires you to use the data, or even if you can demonstrate it, having an overriding legitimate interest. And that's not something which exists under the telecommunications regime. By the way, which is also part of the e-privacy directive. It's marketeers don't read that part, but telecom specialists do.
That's a very good point. Speaking of that, so signals, Wi-Fi signals and GPS, and I want to ask you about the threshold between personal and not personal data with location data. In France, there was that case where JC Decaux, with all the outdoor, digital signage and so on, they were collecting signals from phones that had a Wi-Fi connection open or enabled as they walked by all of these bus stops and whatnot. And then they were collecting MAC addresses out of these devices. The CNIL in France said they could not do it. They even tried to get the Conseil d'Etat to override the CNIL, and it didn't work. But that was out of 2015, if I remember. So how do you see that? Where is the threshold for personal data when you start doing that? If you go into a supermarket, there's so many supermarkets using this Wi-Fi signal to do heat maps, to know how people are moving across the aisles. When do you think it becomes personal data and then we start looking at, a legal basis?
The interesting thing here is that the MAC address itself, in principle, is unique to the device, which means that you could track someone over a long period in time. And if you have enough of that data, you could start inferring patterns, and from those patterns, try and infer who it is. Have more identifying details, but that takes quite some effort. So the threshold is the entity collecting the data able to do it? Not theoretically, but also practically. That's at least the view I've been taking on this, which is even getting more complicated because there's modern day iPhones and Android devices. They change the MAC address frequently, which means that the identifier is short-lived, which makes it even harder to do this. So I would argue that the Wi-Fi, also Bluetooth signals combined with location are only personal data if you have a lot of it over a long time span and a long space in order to do this. There's currently also in the Netherlands a court case in the city of Enschede where they also use this for say, crowd management to find out how many people are in certain areas, these heat maps. And the Dutch Data Protection Authority was actually pushed back by a court because they had not demonstrated that it was actually not only conceivable but realistically feasible for that municipality to actually identify the individual, because they had put in place a lot of measures that would have prevented identification. So yeah, so um, there is a real reason to do privacy by design in these spaces, because if you can demonstrate that identification is not realistic, it's only theoretical, then you may arrive at the conclusion that the data no longer is subject to all provisions of GDPR. Quite some time ago, when I was still working at TomTom, the navigation company, TomTom was caught in the press by allegedly handing over data to the police about folks that were speeding, and that actually resulted in an investigation. And TomTom did not hand over individual data. What they did is they added expected driving speeds to the map. And then the police looked in the map at what the expected speed was, where it was much lower than the maximum speed, because there was no point in putting up speed traps there. So they actually used it to improve their return on investment, so to speak, or optimize taxpayer money, if you like, rather than going after an individual. Because the thinking was, I'm driving around with my, at the time, navigation device, and the fine will follow automatically. Well, that resulted that entire into an investigation by the Dutch Data Protection Authority. And one of the things TomTom had done was devised a anonymization procedure, which stripped the location traces they collected every few seconds, a GPS position. They stripped that from identifiers, but also the beginning and the end. And that resulted in an entire process, which actually was patented. I'm one of the inventors of it, which resulted,
Impressive.
it's privacy enhancing technology with a patent. You can get a license, not very expensive. But that resulted in the Dutch Data Protection Authority basically saying this data, this string of location data, no longer constitutes personal data, because however it is being used, TomTom had an internal policy to not try and re-identify, but also not share it as is with others. So I keep tight control over the data. So it was not personal, but it remained not personal, and that was very key. And to date, that's the way this data is used to predict traffic jams, to predict traffic flows, and so on.
Okay, so I need to ask you one last thing, please. One last thing. Your role in AI. So, how do you see that? Do you see that the DPO will take over some of the AI governance tasks? Is that happening for you, or will we have separate teams dealing with AI governance, just as we have agencies now as per the EU AI Act? Some countries are deciding that the DPA or supervisory authority under the GDPR would be the same. That would be looking after the supervision of the EU AI Act, and in other countries you've got a specific supervisory authority for AI. Will we do the same thing in companies? Will the DPO take over that role?
So the DPO role, of course, is based in GDPR. So GDPR is my legitimation, which means that anything dealing with personal data and personal data processing is something I have to guide, advise on, and also monitor. And in the context of AI, I'd say it starts with generating the AI. And if the AI is built using personal data, I get involved. Then, if the AI is ready to be used, I'd like to know whether the personal data is still in the model, or whether the model is truly an aggregate and abstraction and not containing personal data. Makes quite a difference. Then the third point is when it actually gets used. Is the data, personal data pulled through the AI, actually being used in accordance with the GDPR principles, and the key ones are fairness, accuracy, and transparency in the context of AI. So is your AI fat, so to speak? That's what I'm looking at, which essentially means that I get to see a lot of the AI. But there's also, for instance, a lot of AI I don't see. Now, Uber isn't in agriculture, but if you're in agriculture, there's not much personal data involved. So AI in agriculture doesn't necessarily need a DPO. Now, if I then move to the part of your question regarding who should be the data protection authority or the AI authority, I think the data protection authorities will always have a role. In analogy with what I just explained about the data protection officer, but I also think that AI is a technology in itself which requires a lot of understanding on how it works, what are the risks, the challenges, the opportunities, which means that, for instance, in a few countries, you will indeed see that the data protection authority will take on AI, but they will also have a separate department adjacent to the data protection authority that oversees AI as a technology. And we shouldn't mix them up. The reason also is that the data protection authorities have a very unique, specific position. They are independent. And being independent is a bit at odds because with our regular, normal structure of having three powers, they are a bit of a democratic deficit in a way. So it's really important that this independence is there for a reason, in order to help have someone as a countervailing power against governments and powerful companies. That's great, but I do not necessarily believe that's necessary for oversight in AI purely used for economic purposes in agriculture and so on. So I'm a bit torn between two sides, and I think that a solution in which the data protection authority purely is involved when personal data is involved is fine, but that there is room for other authorities, agencies who coordinate with other authorities in finance, in banking, in transport, in agriculture on the AI used there, because the AI may not be used with personal data. It still could have an effect on large populations, and agriculture again is an example of that.
Very good. Yeah, I mean, we have the Irish DPC scrutinizing Google's models. Let's see how that ends up.
I have the popcorn out, so to speak. I'm watching it.
All right. Thank you. Very helpful.
You're welcome.
Okay, that's all for today. Please follow the Masters of Privacy channel on LinkedIn if you want to find some interview transcripts, cheat sheets, and other useful resources and surprises every now and then. On top of that, episode notes and other feeds are available on mastersofprivacy.com. Thank you for listening.